Countries have made voluntary commitments to prevent climate change under a range of international accords. But do their obligations stop there? Or does pre-existing international law designed to prevent human rights abuses and other harms apply to climate inaction too? An advisory opinion from the ICJ says yes.
Failure of a state to take appropriate action to protect the climate system from GHG emissions may constitute an internationally wrongful act which is attributable to that state.
The court president added that such wrongful acts could include a state's production or consumption of fossil fuels, the granting of exploration permits or subsidies. Such international wrongful acts, as the court opined, can inflict injury on other states in the form of dangerous climate events, making polluters financially liable.
Full reparation to injured states.
The opinion was requested by the island nation of Vanuatu, backed by a coalition of 130 countries after a concerted youth campaign. Pacific Islands are among those bearing the brunt of climate chaos caused by the sky-high emissions, historic and ongoing, of the United States, Europe and China, among others. For youth campaigner Vishal Prasad, Wednesday was a historic day.
6 years ago, young people from the Pacific decided to take climate change to the world's highest court, and today the ICJ has responded. In no uncertain terms, it has told the world that climate impunity is no longer allowed.
The opinion joins a growing mass of precedent, with domestic courts finding both the French and Dutch states' climate inaction unlawful in the past 6 years. COP27 secured the creation of a global loss and damage fund to compensate developing countries, but pledges currently stand at $790 million for a crisis whose impacts are estimated in the hundreds of billions.